Welcome to Chapter 15 of the Wealth Management Essentials course. In this chapter, we'll be talking about wills and power of attorneys. There are 6 different learning objectives, the first one being passing on the estate. We'll also look at other factors to consider when making a will, probate procedures to validate a will, powers of attorney and living wills, and also considerations when dealing with vulnerable clients. Now, when passing on an estate, someone will either be intestate or testate. So intestate, it's when someone dies without a will or having made a will that was revoked, usually by marriage or otherwise invalid. When this happens, the estate is divided according to the provincial intestacy laws, and this can cause the assets to be divided in ways the deceased would not have wanted. Testate is when someone dies with a will. The main purpose of a will is to appoint an executor who can help deal with the process of dividing the estate. And also the other purpose is just to divide the estate or the assets according to the deceased's wishes. There are some different forms of a will. So first, you could have a conventional will. It's generally prepared by a lawyer, and anyone can prepare a conventional or formal will, but clients should consult a legal expert just to ensure that there is proper wording and compliance with the province's formal rules. The will would usually need to be signed by 1 or 2 witnesses as well. Some provinces do not allow the spouse to sign as a witness. There's also a holograph will. So this is a written and signed will entirely in the handwriting of the testator. So no witness signatures are needed. Holograph wills are not accepted in PEI, so that is one exception. They are not recommended and can have some issues arise. The handwriting could be illegible, or the wording may not be clearly expressed, so it might be difficult to find out what the wishes of the testator actually meant. Another form is a notarial will in Quebec. So this will is drafted and attested by a notary. It is signed by the notary, testator, and a witness. Then there's also gifts mortis causa. It's described as the deathbed gift made by a dying person. It is made with the intent that the person receiving the gift shall keep the gift if death ensues. So for the gift to be valid, 3 conditions must be met. It must have been made in contemplation, though not necessarily in expectation. It must be delivered to the recipient without any encumbrance, and it can only be complete and perfect upon the death of the donor. Now, some components of a will. So you need to have the identity of the testator, statement revoking all former wills, appointment of an executor or executrix and a substitute, instructions to pay all debts and taxes as well as funeral and estate-related expenses, and then also identity of the beneficiaries to receive these specific assets from the estate and the residue of the estate. Within a will, there can also be various clauses. The first one being investment discretion clause. So under the relevant law, the executor is restricted to making only conservative, often low return investments for the estate. An investment discretion clause allows for more flexibility, so they wouldn't be restricted to those low return investments. Discretion encroachment clause, it gives the executor the discretion to use assets for the benefit of minor beneficiaries until they reach the age of majority. Life interest in a specific asset clause, this allows the surviving beneficiary, called the life interest beneficiary, to use, occupy, and enjoy the property during his or her lifetime. So an example might be the spouse of the testator receives the income from the property while they are living, but once the life interest spouse dies, it goes to the children. Guardian appointment clause, it appoints a friend or family member as guardian of minor children when they are the recipient of an asset from the estate. Tax election clause, it allows the executor to make various income tax elections on the estate's tax return where appropriate and advantageous. For example, the executor may elect to apply the deemed disposition of assets at death to offset capital losses. There's also the family law consideration. So in Quebec, the testator can provide that the spouse must renounce partition of the family patrimony to be entitled to inherit under the will. In Ontario and some other provinces, the surviving spouse has the right to file a spousal election within 6 months. In effect, a spousal election states that the surviving spouse wishes to take division of net family property under the Family Law Act rather than under the will. Transfer of registered assets. This is a special clause regarding the transfer of registered assets, and it may be included to secure a tax benefit. An example is a rollover of an RSP to the spouse or a financially dependent child or grandchild. Survivorship clause is a common clause to avoid going through the probate process twice within a short time span, therefore avoiding probate tax being paid twice. Now, when there is an amendment to be made in a will, it can be made at any time by a codicil. The codicil is executed and validated like a will and can amend a will by revoking or amending existing clauses or adding new ones. The signing of a codicil must comply with the same formal execution rules as the signing of a will. A holograph codicil must be in the testator's handwriting. A conventional codicil must include the signatures of 2 witnesses to the testator's signature. Now, there are a few cases where someone might have multiple wills, and it is allowed and actually can be helpful in certain situations. One is if the testator owns a residence in another country, it may be useful to have a will for that or those assets. It can also be useful to avoid probate fees in some cases. Restrictions on the testator's testamentary freedom. So testators have considerable latitude in drafting their wills. However, they are restricted under most provincial legislation in 2 regards. They cannot cut a family member out of their will if that person is a next of kin and financially dependent on them at the time of their death. They must provide for their spouse according to the minimum required in the province they reside in at the time of death, subject to a marriage contract. If the will does not provide for the spouse is entitled to claim or apply for division of the assets according to the spousal election. And choosing an executor. So in such cases, the prospective individual should exhibit some or all of the following characteristics. They should be of an age and state of health that they would be likely to outlive the duration of the estate. They should have general expertise in finance, taxation, and investments. They should be reliable and available. They should have personal knowledge of the wishes of the testator and the personalities and needs of the beneficiaries. A corporate executor, such as a trust company, can be used for complex situations where there are a lot of high-valued assets. And executors are usually compensated approximately 5% of the estate value. However, it can be negotiated. And life events that affect a will. So obviously, marriage results in a revocation of an existing will in some common law provinces. The public policy behind this law is an attempt to make provision for the new spouse. And divorce, it does not revoke a will, but the appointments, bequests, legacies, and any other benefits in favor of the former spouse are cancelled. Legal separation does not affect wills in most provinces, so that is pretty important to know. If you ever have a client who is going through a divorce, always recommend that they redo their will. And the probate process. So it is a lengthy process and has many steps to it. The first step, you want to apply for a certificate of appointment of a state trustee with a will. The certificate is a court order identifying the executor and declaring that the will is valid. It also gives the executor control over the estate's assets and liabilities and the authority to administer the estate. The executor must also serve on all the residuary beneficiaries a copy of the application to the court for a certificate of estate trustee with a will. Package must include the following: an original will, affidavit of the execution of the will, and any codicil, usually signed, an affidavit of service of notice stating that the person named in the notice are the persons entitled to share in the distribution of the estate, court fees payable, death certificate, and an inventory of the estate assets. Now, power of attorney. So a will gives an executor authority to administer and distribute the assets in the estate of a deceased after death. In contrast, a power of attorney authorizes someone to make decisions on another person's behalf while the person is still alive. In financial matters, a financial power of attorney may give a limited or general authority to act. If the power of attorney is limited, they are restricted to the power specified in the document. In common law provinces, a continuing power of attorney or enduring power of attorney is a document that authorizes the appointed person to manage the donor's financial affairs, even if the donor becomes mentally incapable. A personal care power of attorney, generally including a protection mandate in Quebec, allows the donor to appoint someone to make personal care decisions if the donor becomes mentally incapable, mainly around medical decisions. And if an individual becomes incapable of making decisions about one's property, the public guardian and trustee takes over decision-making duties as the statutory guardian of that person's property. In such cases, family members of associates can apply to the court to replace the public guardian and trustee and become the incapacitated family member's court-appointed guardian of property. A living will, which is very similar to an advance healthcare directive, provides instructions on the treatment a person wishes or does not wish to receive in the event of a terminal illness or incurable injury. It may be part of the power of attorney or a separate document. And considerations as an advisor. So as an advisor, you should confirm the existence, validity, and currency of a power of attorney at the time of account opening and obtain a copy of that power of attorney for your files. Verify that the Know Your Client information is consistent with the power of attorney provided. And as an advisor, you will be able to notice some red flags when it comes to the client's situation and whether they are becoming more vulnerable and potentially being taken advantage of. This is also why the trusted contact person form has became important in the industry. The idea with that form is that you want to have the client choose someone they trust, but also that isn't the power of attorney. So that just gives the advisor an opportunity to call someone the client trusts if there is ever an issue with the power of attorney. So that's sort of why that document it comes into play. And elder abuse, it is something that has more than doubled among Canadian seniors over the past 2 decades. So it is something to watch out for and look for, especially when you have some seniors that are having more confusion and maybe do become incapacitated. So it is important to watch out for those red flags. And it's good to have things like the trusted contact person form signed, so you do have someone to call if you do think that someone may be taken advantage of. So those are all the important topics in Chapter 15. I hope you found it helpful, and I will see you in Chapter 16.